was. He was a philosopher. And he said that there's nothing so fearful as ignorance in action. Okay? As ignorance in action. There is nothing so fearful as ignorance in action. And so you go in there with your superior knowledge, supposedly superior, and these people don't know what you do, and they just might go into action. And you might find yourself behind bars, all because you knew something they didn't. And you knew that it didn't matter whether or not you wore a hat. But they told you to take the hat off, and you didn't, so you went to jail. Okay?
Well, that's the only thing.
I suggest that you don't challenge the people around you. Remember this. There's a very important rule. In the land of the insane, the sane man will be adjudged insane.
Yeah.
Okay?
That's true.
So understand who's around you, and you know, you got to put a proper show on, and you got to take into account that you're not actually free, even though you think you are, because you can get these kickbacks, or blowbacks, I think is the new term. Well, basically, you had to put up with either their lack of knowledge or their choice to ignore what they knew.
Oh, yeah, they did.
That happens. Well, anyhow, so keep in mind, as I said before, what sovereignty is. Keep in mind that the number one rule about courts is that it's a show. You want to put on a good show. And even though you're right, if it's a bad show, then don't do it. Don't claim it unless it's really, really critical to what you're doing. Keep in mind what a court of record is. And that is proceeding according to the common law, and don't allow the judge to make any decisions. Okay? Now if you're the sovereign of the court, you're the plaintiff. If the judge makes a decision, all you do is you object. We have on this disc, what do you do when you are in front of a judge? Okay? This is very important. See, when you have your paper, when you're in your court process and you've done your counterclaim, if you're in front of a judge, the reason you're there is because somebody, either you or the other side, is asking the court to do something. That's called a motion. Okay? And so the judge is going to try and make a decision. If it's your court, and you have a court of record, he cannot make a decision. He's prohibited. But that doesn't mean he won't do it. And so when you're in front of that judge, you want to be able to keep things under control. And under control in the sense that even if he doesn't do the right thing, you're not lost. Okay? So you have to be the plaintiff, as I said before. Now here's what happens. I'll just read off this article. It's short and sweet. When you are a plaintiff and one of the people of the United States or a state in a court of record, the judge has no power to make a decision unless you grant it to him. The tribunal, which is either you or a jury, is independent of the magistrate, and all judges in California are magistrates. When in court, there is no need to argue your case. All of your arguments should have been made in the preceding paperwork. The only reason for a court hearing is to give the court an opportunity to ask questions of the litigants to clarify any points. Anything you say in court is considered an ovation to your papers on file. Your verbal actions override your previous papers. That's why you don't talk in court. Now, get this. Somebody makes a motion. That's whatever it is that he wants. Says, I want this from the court. The other person answers the motion from his side. And he introduces his own peccados, whatever. And then you have a third chance to come back and say whatever it is, but your answer, your reply to his answer is narrowed down to the issues that were raised in his paper, okay? That's your typical 3-paper set. Everything you have to say should be in those papers. Basically, you spoke on paper and the other side spoke on paper. That's your speaking. The only reason for a court hearing is so that the court can ask you questions. That's it. A court doesn't have to have a hearing at all. And in fact, if you go down to Florida, down there in those courts, you put your motions in and you get your rulings back. You never have a hearing. Normally you don't have a hearing. Why? Because those guys down there, apparently they feel they understand your paperwork. There's no need to call you in. If they do have questions, they'll set a hearing date, notify you, and you come in, and then you talk. But the only purpose of a hearing is to give the court a chance to speak or ask questions to clarify points. That's it. Your argument is through when you put that paper in. So knowing that, here's our procedure. Just as I said, when in court, there's no need to argue your case. All of your arguments should have been made in the preceding paperwork. The only reason for a court hearing is to give the court an opportunity to ask questions of the litigants to clarify any points. Now here's some suggestions on court procedure. First of all, don't verbally discuss anything in court. Nothing. The judges and attorneys in court are word masters. They are much more practiced at word interpretation and manipulation than you are. Anything you say will be held against you and will provide opportunities to nullify your paperwork. The best thing is not to discuss anything. When the judge asks you anything about your papers or points, you should only say, "I have nothing to say. It's all in my filed papers, Your Honor." Okay? That's it. Do not discuss it. That forces the judge to consider your papers rather than what you may say in the hearing. You open your mouth, you're dead. Okay? Because now he interprets. You say it's raining outside, and he interprets that to mean there was no rain at all. You know, you have no control over his interpretations. Therefore, don't give him ammunition. All right? He wants to know what you have to say. It's all in the paperwork, Your Honor. I have nothing to say. Second thing, object to anything of which you do not approve that occurs in the courtroom. Okay? I object to the hearing. Of course, if you made the motion, don't object to the hearing, okay? But if the other side made the motion, you object to the whole thing. Whatever it is, whatever they say, if you don't like it, object to it. Certainly don't allow any decisions on the part of the judge without objecting, okay? He makes a decision, you object, all right? So here's a script. Typical courtroom scenario. Something happens in the courtroom, whatever it is. You say, "I object." The judge says, "Why do you object?" You say, "It's not my wish." The judge says, "If that's the best you can do, you're overruled." And you say, "Well, for the record, I do object." And then he says, "Your objection is noted." Okay? And he might even say, "You're overruled." Well, what you did is you registered your objection. That keeps it open. Yes?
What about I take exception to your ruling?
Well, if you want to be an entrepreneur and create new procedures, that's up to you. But I suggest you follow the standard procedure, which is to say, "I object." You know, otherwise you're taking a chance.
No, that's the second one. You object, he says overrule, then you can say I take exception to that.
Well, if you want to, you can. I mean, but once you've objected, that's it. I mean, he made the ruling. That doesn't mean that he's authorized.
It's on record.
It's on record. You object. Okay?
So can he find you in contempt if you keep objecting to his rulings?
Well, it doesn't normally get that way unless you've generated a lot of hate in the courtroom. I mean, I keep these things friendly. You know, I mean, if the judge finds you in contempt because you object, that tells me that something's wrong here in how you handle things. Because objecting is such a standard procedure. Nobody's going to find you in contempt. You're telling me that he's using it as an excuse to carry out another agenda. All right? So I suggest that you get to that stage, something's wrong. You should have been alerted to yourself long before that you're not handling things right. Just to object, you know, and you don't have to be loud. You don't have to be obnoxious. You say it with a smile. You know, "I object, Your Honor."
How do we get the report for that?
No, don't you know when you object?
Well, if it's not recorded now, oh,
It's recorded in your memory.
oh,
I mean, you just move forward on these things. You make your claims. In your paperwork, when you file paperwork later on, you state in your paperwork that you had objected. Whatever your follow-up paperwork would be. That becomes part of the whole history, of the court proceeding. Yeah, I understand that they don't always put things in the record that they should have.
Make notes,
Huh?
make notes.
Yeah, they don't always make notes. You make notes, but they don't. So anyway, but you see that little proceeding, just as I showed it there, that's really all that's necessary. My hearings seldom last more than 5 minutes. Okay? Because I don't stand there and argue. I just say object and I let him roll on. What takes me a lot of time is the full day or 2 days it takes me to write the paper to reverse his decision. But that takes time. But, the actual proceeding is extremely short normally. Now, I have no control over the other side, but usually the other side doesn't have much to say either. But you can encourage them to say more if you want and run your transcription expenses up. But if you just keep it simple and say, I object. Okay? All right, so that's all that is necessary. You then move on to the next item of business. All right? The judge is going to do whatever he chooses. You have not the power to stop him at that time, just as you have no power to stop a robber from robbing you. At this point, your only goal is to object for the record. Later, after you leave the courtroom, you type and file the court order to vacate or correct the judge's decision. But remember, this can only be done if you are the plaintiff, one of the people of the jurisdiction, in a court of record, and have not given anyone, including the judge, any permission to do anything in your case. Okay? You've got to have this thing locked down. And so if you're in a court of record, it's an absolute, no exceptions. The judge cannot make any decisions whatsoever. Okay? You are the decider. And then finally, point number 3 in a proceeding, if you are, let's say, incarcerated, and they bring you out before a judge, then this next paragraph applies. If you are a defendant who is the petitioner in a habeas corpus or a plaintiff in a counterclaim, you should repeat to the other court your demand to be released. You are challenging jurisdiction. Because they asserted jurisdiction, you should from time to time remind them of your demand to be immediately released from their custody. They probably won't release you, but again, you're building the history of the case, and this all works against them in the long run.
Do you become an injured party if they continue in custody?
Yes.
Okay.
Yes, you become eventually an injured party because they held you without jurisdiction, assuming that's the point, assuming that you arrive at the point where you've determined that they don't have jurisdiction.